Welcome to the Harvard Law School Library Book Talk for Unjust Debts, How Our Bankruptcy System Makes America More Unequal, by Melissa Jacoby. You can get a print copy of this book from the Harvard Coop right outside the store or at the Coop, or check it out from the library. We'd like to thank Dean Goldberg's office for their generous support of the Faculty Book Talk series, as well as our librarians Lisa Wright and Sarah Newberg, Debbie Ginsberg, and Maya Bergamesco for their assistance. Before we get started, please silence anything you have on yourself that makes noise. Thank you for doing that. And we're welcomed today by Melissa Jacoby and Mark Rowe. Melissa is the Sullivan and Cromwell Visiting Professor of Law at Harvard Law School and the Graham Keenan Professor of Law at the University of North Carolina at Chapel Hill School of Law. She teaches commercial and bankruptcy law. Mark Rowe is the David Berg Professor of Law at Harvard Law School, where he teaches corporate law and corporate bankruptcy. I'm going to turn it over to Melissa, who's going to spend a few minutes talking about her book, and then we're going to have a nice, robust discussion like we're used to, and then we'll have time for audience Q&A. Thanks so much.
Good afternoon, everyone. I'm going to stand and talk a little because I've heard, can you hear me okay? All the way on my left side, awesome. So thank you to the library for having me. Thank you to Professor Rowe I'm really excited to have this conversation. And thanks to the audience for being here, both in the room and virtually. I know that bankruptcy isn't something that everybody naturally gravitates to and thinks of as a core subject. Of course, Professor Rowe and I might think about it a little bit differently, but I wanted to set the stage for you a bit on whatever you're doing, especially, are there one else in the room? Great, about why and how this connects to the kinds of things you might be already thinking about. After all, one of the concerns of my book is that bankruptcy is taking up too much of the legal system. It's encroaching too much on issues that you're studying in these other courses. So let's start with some foundational principles. So bankruptcy is in the Constitution. Article 1, Section 8, a skinny little clause that's talking about that Congress can write uniform laws of bankruptcy. Now, why would they do that? Well, one debtor, let's say I'm the debtor, I owe all of you money, and including the people watching virtually. I owe everybody money, and there's one of me, and I cannot pay all of you. There needs to be some coordinating device to treat you all equally. And once upon a time, states might have preferred, Massachusetts residents would prefer its own residences, and Pennsylvania would prefer its own residence, and there would be a better coordinating device. This bankruptcy power also enables cancellation of legal obligation, and that is a big legal deal. And we can't find that at state law for the most part. Now, Congress has expansively interpreted this power, at least I would say, supersized it, if you will. And so we have to recognize that this little clause is going to be already doing a lot of work. But the constitutional law intersections go beyond this. Due process is challenged and in tension in a lot of bankruptcy cases. After all, the consequences of a bankruptcy, which might terminate legal rights forever, are a big constitutional deal. There better be notice. And in addition, bankruptcy courts do not have life tenure. That raises all sorts of problems and challenges for the Supreme Court about the constitutional authority of that court to make decisions. And so one more intersection with con law is that constitutional violations are treated like debts, just like a credit card in the bankruptcy system under current law. Now, I don't think that's right, but that's what it is now. So let's just throw in another couple subjects here. Torts. If you can include a constitutional violation as a claim, well, certainly torts of all sorts are included and are treated as creditors in a bankruptcy. And some bankruptcies are primarily for the purpose of capping liability to lots of different claimants. And that's something that Professor Rowe has been writing about and thought about for a long time. Let's bring in contracts. Invisible in every contract is a clause that says your enforcement right changes if one of the parties files for bankruptcy. Now, the bankruptcy clause inherently changes contracts. That is sort of the superpower that it has. But bankruptcy law goes beyond that. Bankruptcy does more to contracts than I think it probably should, or is necessary to fulfill its main function. Property. We need to know what property the debtor has if the property is going to be divided up to compensate all of you. So what is my property? Well, we start with state law, of course, but then bankruptcy law gets a little greedy sometimes about what they want to consider a property so that they can make there can be more. Other times, it wants there to be less. It recharacterizes transactions that were thought to be property transfers under state law. Finally, civil procedure. Bankruptcy is part of the federal courts. Federal rules of civil procedure apply, special bankruptcy procedure, federal rules of evidence apply. And yet, there are some major twists. One of them is that unlike in any other civil action where you have a lot of standards to overcome to have an injunction, in bankruptcy, you automatically enjoin otherwise lawful activity. That is a really big legal deal. There is coercive federal authority going on in the system that subverts what you might otherwise expect. So in short, it takes a lot of fundamental concepts and it sort of shatters and remixes them in a very different way. Now, why should you care about this? Maybe this is rare. Well, 1 out of 10 living Americans have been through bankruptcy at least one time. So people all around us have gone through this process, have had severe financial distress. Whether the system has worked for them or not is something I try to address in the book. Mega cases, the ones you read about in the newspaper, Purdue Pharma, Johnson & Johnson subsidiary, the Boy Scouts of America, those can affect hundreds of thousands of claimants directly and many more indirectly. There are businesses of all sizes, churches and other religious organizations, nonprofits, and even cities, public hospitals, sewer authorities, water authorities. It's not that common, this group, but those cases bring in a lot of people and have a lot of effects. So now, maybe you think, well, another thing we focus on is the administrative state here at Harvard Law School. So is bankruptcy part of that administrative estate? Well, not exactly, but there are some twists. So the institutions that we deal with in bankruptcy are the bankruptcy court. That's a unit of the federal district court. And yet, because it doesn't have Article III authority, they are not life tenured, there are challenges there. So opinions from the Supreme Court on the administrative state and the power of administrative agencies affect bankruptcy courts and vice versa. So you got to watch out for those rulings. Another institution that people don't think about is part of the Department of Justice called the United States Trustee Program. That is a watchdog for the system, administrative oversight. So now what about the issues? Surely we only are talking about debts, loaned money. Well, no, I've already told you about constitutional violations, torts, and the like. Bankruptcy has gotten broad. The definition of claim and debt is very broad, and its scope is even broader. So issues like climate change and the environment, healthcare, employment law, retirement security, all of these things, even energy policy, end up being dealt with in a bankruptcy case. So there's a lot going on in this system. Now, in terms of the book, a couple things I want you to know about my approach that we want to think about. Conceptually, as I've already hinted at, I don't think of this area as a purely private law area. It is a hybrid of public and private interests. It involves coercive federal power. It has to have that hybridity. And so I also don't necessarily think that a system can accomplish or aim to accomplish only one thing. It is balancing competing objectives. That's how I think about things. A fancy term for that is normative pluralism. Another way to say it is balancing different things gets you to the same place. In terms of my research methods, I like to observe and go bottom up in cases. I do a lot of case studies. I have been involved in systematic studies of the system, but I like to dig deep and use primary sources. And in terms of writing style, I like to tell some stories. So this is a book of stories. It's not a book of arguments. It is written for a trade press. I wanted not only law students maybe to want to read it, but people who never want to go to law school ever. And so stories can help people understand how it works, and that's what I'm aiming for. So I think we'll end up talking about some of this. Inequality is in the subtitle of the book. The publisher put it there. Inequality is a main frame that I'm looking at the system in, but it doesn't stand alone. Economic efficiency is an important lens on which to look at many laws, including this one. I just don't think it's the only lens that we look at. And luckily, for me, maybe, the two often are swimming together. In other words, the things that I worry are generating inequality, there is also evidence of economic inefficiency. I add federalism because federalism gets tossed around a bit in discussions of bankruptcy, but not as sustained as I might like. And I think that bankruptcy is ending up overriding way more state law, state policies, and the like than is healthy for the system. And so again, I see these as sometimes swimming in the same direction, that we can look at them as a group. So the book talks about race disparities. I compare fake and real people, by which I mean corporations and humans. I talk about mission creep, about how a system designed to help negotiate new deals among lenders is being used for all sorts of other kinds of policy problems. And ultimately, there's a connection back to the legal system generally. This is a system that you learn that the remedy is often the payment of money. So debtor-creditor relations are created by all sorts of legal obligations in our system. And we're seeing that funnel back into the bankruptcy system. So ultimately, I let everybody label this project as they will, but I see it as a somewhat small c conservative approach, ultimately advocating for a narrower, more targeted and effective bankruptcy system that actually takes up less space in the legal system and more for everything else. So I'll just leave up my table of contents here in case that helps in our further discussion.
Well, good. Melissa, maybe we should be Melissa and Mark for this
Sure.
event instead of professors. This is a good project. It's a good project because the frame of reference for most people talking about bankruptcy has been on the prior slide, that the efficiency idea is, how is bankruptcy inefficient and making things worse in terms of running businesses? How is it making it better? How is it contributing to financing of business, or how is it deterring the good financing of businesses? What I particularly like about this project is there's a whole new frame of reference of how does bankruptcy interact with the social system? How does bankruptcy interact with inequality in the United States? And maybe that's the first question. We've talked about this before. So the subtitle is how bankruptcy makes America more unequal. And the question is are we attributing too much to bankruptcy? Is that, while bankruptcy people want to say bankruptcy is really important, is this really reflecting society as opposed to being a significant contributor? That is, society is unequal. You have some nice discussion about how racial minorities tend to be steered to a less favorable provision of the bankruptcy code. But there are a lot of studies showing that happens in multiple dimensions. This is one of them. So a question to start out with is bankruptcy in these features reflecting or contributing? And if they're doing both, which is the dominant one?
Yeah, so I think it is both, and it is absolutely critical to recognize that bankruptcy takes people where they are, and they are bringing existing inequalities into the bankruptcy system, no doubt. I am a little bit of an outlier in the bankruptcy system in that I'm trying to make my own field smaller and less relevant to too many things. So I think that bankruptcy is an example of how very technical areas are amplifying inequality in ways that are less visible than some of the more salient features of our society. But there is no question that a lot of it is brought in, and then bankruptcy piles on. And so part of the obligation of the book is to give different examples of the piling on, of saying that even though it is understandable might not be the right word, even though it is not a surprise that African Americans are overrepresented in the bankruptcy system relative to the general population because of the wealth gap, because of the income gap, that there are things that bankruptcy itself does that change and lead to disparate results. And there's the most robust research here on controlling for all sorts of other variables. Nobody wanted this to be the story, and yet here we are.
If your sole goal was to reduce inequality, would you address bankruptcy first, the tax code first, housing policy, schools? Where would bankruptcy be on the list?
Well, it would be low. And I have to say that as a citizen of this, a resident of this world, that I would not start with bankruptcy. And yet sometimes we have to start with places we can actually address. So one thing that I think is really important for people to see about this field is that on the congressional side, and also in terms of Supreme Court jurisprudence, I'll put the congressional side in terms of bipartisan, and I'll put the Supreme Court jurisprudence in terms of sometimes people who are not considered to be ideologically similar. That both when I've liked bankruptcy legislation and when I've disliked intensely bankruptcy legislation, it's been bipartisan both times. And so I think that bankruptcy is an area that could be changed, but it is absolutely not where I would start if I was trying to get at the root of inequality in America.
Is there a case that bankruptcy helps with inequality, reduces inequality in this way? People take on debt, credit cards, overextended, use the credit card to buy food because money's run out, then a big medical expense. And one feature of bankruptcy is that Chapter 13, there are bankruptcy solutions for individuals. They may not be particularly great solutions, but there is something there. Yeah. And so is there, when you're listing how bankruptcy contributes to inequality, there are also some things that go the other way.
For sure. And I think that this is a really important point to say bankruptcy can be an engine of reducing inequality in that respect, to say, as it is a blunt instrument, to be sure. It does not retrain people for jobs. It does not hand out money. It cancels debt. That is its biggest superpower. And that can itself give people a chance to better compete, to start a new business, to help send their kids to college, whatever it is. So yes, and I think that's why it is particularly troubling when the bankruptcy system is piling on, when it could be an engine of promoting equality or reducing inequality. So, and that's why ultimately, I'm not going to be the one to say banish the bankruptcy system. I might narrow Chapter 11 for corporations, but for individuals, there has to be something. And there are economists who have written about this who agree to say a targeted, effective method of canceling debts would be good economically, but also, to me, go toward this point.
This is a question I don't know the answer to, and and you might not know the answer to it either, but I'll put it out there.
Happens every day, yeah.
I'll put it out there. So one of the features of American bankruptcy, which is different from almost every other bankruptcy system in the world, is that we combine individual bankruptcy and corporate bankruptcy in the same system. And to the point that several chapters of the bankruptcy code, critical chapters of the bankruptcy code, apply both to individual and corporate bankruptcy. And you can see where this is leading. So we have things where we're dealing with a corporate restructuring where it would be plausible to say efficiency and financing are the central norm. And once that decision is made or the interpretation of the section is made, that same section and interpretation then applies to the next bankruptcy, which is somebody who's just lost their job and piled up debts and files for bankruptcy. I don't know every bankruptcy system in the world, but my impression is that almost every other bankruptcy system in the world keeps the two either completely separate or largely separate. And the consequence is that you can have one stream and one institutional stream for individuals, which is social justice oriented, and another stream for businesses, which is more efficiency and finance oriented. But we put them together in the United States. The same judges who decide both. It's the same bankruptcy code. There are only a few provisions that apply to one and not the other. And I guess the question is for you, is there anything to riff on there that this is one of the sources of the problems you're identifying in the book?
Well, I've been thinking about this since I think it's a really important point to say, would we be in a different place if the systems had developed separately? Now, if I recall, it took a while and did go up to the Supreme Court whether humans could use Chapter 11, and the Supreme Court said yes, they could. Nothing in the code said otherwise. And since then, there's been more and more in the code that makes clear that things apply, that many of the laws apply. Indeed, we often have law made about a truck from an individual that affect the interest rate on billions of dollars of debt in big Chapter 11s. So I think one thing I would say in response is that there is actually a spectrum, and that in the middle we have very human-intensive businesses, some incorporated, some not. Some are doing business as sole proprietors who are being treated as individuals in the bankruptcy system. And so we have a spectrum of human to big corporation, and we'd have to disentangle that. The other thing is, I'm wondering, even though one of the theses of the book and some of my other work is that corporations, especially big ones, are much more generously treated by bankruptcy law than individuals, even with the same code, would the situation be even worse assuming you agree that that's not desirable, if they were completely separate? I am willing to have economic efficiency be part of the analysis for personal bankruptcy. But I also think the issues of inequality need to be part of the calculation on the corporate bankruptcy. So I wouldn't want to say that they have those two different goals. But I think we could have a decent system either way. But I do have some worries that separating would further exacerbate that there's been some carryover benefits on personal bankruptcy that make it better than it otherwise would have, given the politics and the lobbying that go along with only focusing on personal bankruptcy.
Because when amendments to the bankruptcy code are put in place, people who are interested in the social policy portion or individuals can make a deal with people who want to make sure their lien will not be challenged.
Well, yes, and as I've learned from you, politics does sometimes come into the making of laws, corporate, commercial, bankruptcy, and otherwise. And we have some very big lobbying interests that are proud to say the consumer credit industry that takes lots of credit for a big round of amendments in 2005 that were roundly criticized both on the theory, but also really on the practice of just creating disruption for the sake of disruption and cost for the sake of cost, rather than putting money in individual creditors' pockets. So I worry about that going even further.
One of the interactions that you have in the book, or maybe I should just suggest you talk about it to the group, it is the interaction in corporate bankruptcy with mass torts, which is an issue.
It's an issue.
What is the issue?
Well, can everyone stay all afternoon? Because we have a lot to talk about here. So the bankruptcy rules for big enterprises, whether for profit or nonprofit, were written as both as a package deal, with voting being very important, weighted voting, so that creditors with bigger claims would have more of a say, and also they were supposed to have protections that whatever happened in the case, they would be at least as well off as they would be if that company or nonprofit liquidated. That's called the best interest of creditors test. When you have a company that may not even be in financial distress, but says, wow, I've got a lifetime of torts coming and I want to manage those, it is understandable to, in theory, to say bankruptcy offers the tools to get our arms around this and treat creditors equally. The problem has been that the theory has not played out in practice, at least in the cases where we're able to follow all the way through. And it's led to very unequal results on the money, but also real challenges on due process, as well as issues of procedural justice, perceptions of other reasons that people went to the legal system, that it wasn't getting a check, assuming they even get one, which they often don't, but because they wanted to confront the person who wronged them and ask them questions. They wanted to have a day in court in front of a judge. And bankruptcy, in striving for, I think, economic efficiency, saying this is a better way to do it, has lost sight of some of those other goals. I think some judges and lawyers are trying to put those into the picture, but not necessarily effectively. But I still also question whether it's even achieving the goals that those who are optimistic about mass tort bankruptcy were hoping for: equal treatment of creditors with similarly situated problems. I'll just throw out one more thing in the interest of time, but also this is very much in the news with Johnson & Johnson and their talc claims against them. There is an issue that this is harder to do with commercial claims, but claims that people who may not actually have an injury that is connected at all to the company, or may not have much of an injury at all, that have been recruited by profitable corporations to become part of the case, to outvote the people who are on the verge of a jury trial, have the most severe claims, and have done the most work investigating the causal connection between their claims and the product. And I think that really has to be worked out. Courts are really important to that process, but a lot of times that's sort of pushed off till after the case has already been, the debts have been canceled and it's sent to a trust, and they're supposed to work it out. So those are just a couple of the issues I'm struggling with.
I don't want to defend bankruptcy and mass tort because I consider myself largely a critic of what's been happening. Let me add this, though, as a question. Does this reflect, the first question is that the mass tort problem could be dealt with outside of bankruptcy, and there's a good case that it should be dealt with outside of bankruptcy. And what bankruptcy is good at is, here's $1 billion that's owed by the company that's only worth $500 million. Let's allocate it in the most effective way. But with the demise of the class action, with the inefficiencies of multi-district litigation, I don't want to make bankruptcy people into heroes, but there is a heroic notion that at least one judge in New Jersey seems to have, which is, okay, the rest of the world isn't dealing with this problem. I will stand up and deal with it. Maybe I won't do it right, but at least I will deal with it. And so the question is this also something that bankruptcy is reflecting what's happening outside of bankruptcy, and it's not being handled well, so it moves into bankruptcy, and depending on how you look at it, bankruptcy also doesn't handle it well, or maybe if you're one of the heroic judges, you think we're at least doing a little better than the other guys were doing.
Yeah, and I will echo the idea that I think some in the judiciary, as well as some of the professionals involved in these cases, truly believe that they are helping and they are trying to solve a very difficult problem. I don't mean to ascribe any other motives to them. There, of course, are a range of motives out in the world, But I believe that that's earnest. So my problem with that is, so I'd say yes, absolutely background conditions. There is a problem that needs to be solved. I think that bankruptcy is not the ombudsperson for the civil justice system, and can't solve problems that are coming up elsewhere. And the second thing is the errors, when these cases don't work out, the consequences are even more severe because their rights have been permanently cut off for significant harm. And so, and that's, we haven't even gotten into, these cases are trying to stretch out into the future, change the legal rights of people 10, 20, 30 years from now who don't even know they're going to be injured based on a past exposure. I worry that those consequences are too big, but I have to agree. I am not here saying everything's working great outside of bankruptcy. And I do think bankruptcy could work with other systems to do the part it does best and leave the other parts to the other institutional actors. And I think originally that's how it was supposed to work. The bankruptcy wasn't supposed to cut off every possible trial. You would have bellwether trials to see about causation and lead to facilitating settlements. And you'd have other parties, other federal judges involved. I think what's happened is an idea of let's get it really all in one forum, because then the leverage associated with bankruptcy is incredibly strong. And that's where I have the most concerns.
Maybe we ought to do questions from before Melissa and I gobble up all the time talking about our interest in bankruptcy.
All right, if we could give a quick hand to our speakers. Thank you for coming. We are going to turn it over to audience Q&A. So if you have a question for our speakers, please raise your hand and someone will, my colleague Lisa will come over. Our first question is actually coming to us from a Zoom viewer. So I'm going to pass it to Debbie to ask the Zoom question, and then we'll go from there.
All right, so the first question is, how historic was the Purdue SCOTUS decision, and is it common for companies to spend $1 billion in bankruptcy legal fees?
It is not common to spend that much in legal fees for bankruptcies overall. The vast majority of bankruptcies are filed by financially distressed families. But among the mega cases, the professional fees, I think it's fair to say, I'm deferring to Mark here, are eye-popping. And we have to compare them to how it otherwise would have worked out in another legal regime. It's not legal fees versus none. But that was a particularly large amount of money. But the fees in the biggest cases, the hourly rates exceed $2,000 an hour. And again, it is a bankruptcy. Part of the point is it's supposed to be financial distress. So it is understandable that people are thinking about that. The Purdue Pharma case was a long time coming in resolving a long contested circuit split. And it went in favor of interpreting the bankruptcy code in a more narrow sense, consistent with prior Supreme Court decisions. Depending on whom you ask, this is the most calamitous thing in American law today. But I think most people don't go that far to say that it does shift leverage in these cases, but it leaves a lot of room open for negotiation and other solutions. So I think we are seeing a shift in how these cases are going, and courts are working very hard to interpret and apply the Purdue Pharma Supreme Court decision. Literally every day we get a new piece of information about that.
Hi. So Unjust Debts strikes me as an important contribution in its own right. And also it forms part of this broader growing canon of scholarship that identifies large-scale patterns of institutional change that are contributing to inequality, such as Katerina Pister's The Code of Capital, about how the law codes assets as capital, and Julie Cohen's Between Truth and Power, about how information technologies are transforming legal power structures. I know you mentioned some of these in your book, I believe Jacob Hacker's. And so I just wanted to invite you to share thoughts on how your book kind of extends, complements, challenges, or otherwise adds to that canon.
Sure. So because the book was meant for the general public and is a book of stories, I implicitly but not explicitly engage in some of those discussions. The connection with Katerina Pastor's work has actually come up in quite a few conversations, and in a review that's going to be in the Harvard Law Review of the book, I think that's one of the main things that the reviewer is going to be discussing. So I do see those connections, and I appreciate, I'll leave it as to be continued in a discussion, but I appreciate the chance to both contribute to those debates while also not excluding people who are actually affected by these cases from being part of the conversation.
Thank you. So I read your book with great interest and expectations, and it delivered on every front, because I feel like what you're doing here is showing the capture of a legal system, right? It's not an agency capture. I like the analogy to administrative state, but the siloification of bankruptcy law allowed for a quicker and more demonstrable capture of it by larger powers, corporations, whatever. And so chapter 6 of, from over, like you're showing how an industry uses the code because of its superior knowledge and specialty against its own aims, right? And how that the bankruptcy system sort of was defenseless to it, because you have these, it's so separate from the normal sort of court system, but also so powerful, right? You're taking these companies, I mean, you have the liability management, but you also have just bankruptcy as a business plan, right? This is, we owe too much in pensions to certain pilots, and so we're gonna, every airline goes through bankruptcy to avoid paying these pensions, right? So that part I thought was just really worth emphasizing, but also I wonder if the solution, your remedy, is to make it smaller, or to maybe like put it, maybe make it more harmonious with the other legal system. Maybe maybe putting it in a silo allowed for capture rather than integrating it into the system. There's no reason for it to be over there. You have forum shopping and all of these bad incentives that occur. What do you think?
Yeah, so I do think on your latter point, I think there is argument for more, rather than a turf battle we sometimes see in cases involving energy, for example, there are, you see whether whether FERC, the Energy Authority, or the Bankruptcy Court get to control, and they act like it has to be one or the other. And I think there should be room for more collaboration between these institutions. On your first point, I'd like to generalize this, especially for the students in the room, to say sometimes complexity and siloing really increases power, because the message is, you don't need to know what we're doing over here. Don't worry, the experts are in charge. And that's why the jargon and the like, it's important to overcome that. There's a glossary in the book. Occasionally the entries are just a little bit snarky. I try not to go too far, but that you deserve to know, and that the complicated terms should not block you from having people explain it to you in a more comprehensible way. So I'm all for the unsiloing. I see Justice Breyer, but
Question?
yes, please.
35 years ago, I was Chief Judge of the First Circuit,
Yes.
Boston, and they held the bankruptcy every year. They hold the bankruptcy convention at a place where the president of the bankruptcy judge, who's the head of the association, does his work. That was Boston. So I went. I was invited to speak. And I saw a hotel. It was the hotel by the freeway there, but huge room, absolutely huge, filled with lawyers and judges. So I said to him, this is amazing. We have First Circuit conferences every year. We can never get this many people. I mean, nowhere near. And you have, I've never seen such, it was a very big crowd. I said, why are they all here at the bankruptcy? And he said to me, the reason is because this is where the commercial law of the United States is being made. So my question, and that's been in my mind ever since, is that true? And if it is true, is it still true? And I thought, well, I know nothing about this, but better somewhere. And Judith Resnick's written on this. Nobody's going to court in the commercial area. They're all going to mediators and arbitrators and the international, maybe I should add this, you don't want to know, said the president of the International Arbitration Association in London. And I said, I want the true answer. Why? He says, you don't want to know. I said, yeah, I do want to know. He said, okay.
I'll give you a
We have
partial answer.
better judges. All right. Okay, but you see my question.
There are a bunch of things that isolate the bankruptcy system from the rest of the judicial system and from, so embedded in the bankruptcy code are several provisions that say, once the transaction has closed, you can't undo it. So appeal it if you want, but whatever you say on the Supreme Court, it's not undone. And that then interacts with what an appellate judge will do. An appellate judge is being told, maybe railroaded, but being told by somebody in the courtroom, the transaction is moving, and if everything's okay, a bankruptcy judge who's experienced in commercial litigation and business has already blessed this. And if you hold it up to have a full-scale litigation, I can't tell you how many people are going to lose their jobs and this business is going to fail. So the appellate judge is frequently unwilling to look underneath the hood of what the transaction is. In addition to the provisions in the code, there are doctrines, equitable mootness, that even if the code doesn't say it can't be, the transaction can't be undone, there are doctrines that say you shouldn't, judicial-made doctrines that say you shouldn't undo it. Those kind of put, force field is too strong, but something like a force field around the bankruptcy system in that it operates and it operates with some oversight by the appellate courts, but not as much as somebody who's doing the federal courts course would think. Won't go into the technical things, but recently Supreme Court read the bankruptcy code and says you can't do this. Within minutes, bankruptcy lawyers were saying, oh, we can, because we can manipulate through this, and the bankruptcy judges will bless it first, and then the appellate judges, and just as they predicted, that's happened. And maybe in 10 years it'll hit the Supreme Court again, and the Supreme Court will again say, we told you in 2000, I forget when that, right? 2020, you can't do this. And in 2032, they'll do it again and say you can't do this, and then somebody will find another mechanism that will last for a few years. I mean, occasionally, this overstates somewhat, but I occasionally think when I see some of these bankruptcy maneuvers, I think of Andrew Jackson saying, Justice Marshall has made his decision, now let him enforce it. And there are a number of times that the bankruptcy bar thinks the Supreme Court has decided, the appellate court has decided, but we're going to do it the way we want to do it.
And I would add to that, I endorse that, I would have said, I agree with a lot of what was just said by Mark, and I would add that first, in teaching state commercial law, including to some students in this room, we use a lot of bankruptcy court decisions. And it's not because we are learning bankruptcy law, although we have to dip into it a little bit, but because they are more likely to have published decisions on this. State courts sometimes don't have law clerks. State courts have more limited means. What that also means, and this is a little bit of a pitch, is that you still need to know the state law. What I worry about is that in the bankruptcy lawyers are so learned in so many ways, but there gets to be this bankruptcy gloss on state law issues that may not technically be exactly right. And that's why I keep emphasizing we need to go back and look at that original state law authority in the Uniform Commercial Code and otherwise to do that. But I do think they're still performing that the predominant commercial law court today, with a little bit of competition from maybe some of the specialized business courts that some states are adopting, although that's more to compete with Delaware on corporate law.
Thank you both so much for your insight. Thank you, everyone. Our next book talk, the final one of fall, will be in this room on October 16th, The Quiet Coup, Neoliberalism and the Looting of America. So we're so excited to see that one. So come back then. Thank you again so much, everyone. There's still some lunches left if anyone didn't grab one. Thank you so much.